All right, guys. So this morning we're gonna talk about power of attorney. It's kind of a quick meeting, just because there's only so much that I can kind of cover. But do you guys know, or who can tell me what a power of attorney? What does that mean? Let's see. April, what's power of attorney?
A person that can act on a member's account.
Okay. Does anybody have something to add to that?
Like a fiduciary side.
Kind of. That's a little different, but yeah, similar. So it's pretty much the authority to act for another person in specified or all legal or financial matters. And someone tell me the parties involved in a power of attorney. Yolanda, you look excited.
So it would be the
One person. Just tell me one of the parties involved.
the person acting for another person.
And what do we call that?
The POA.
Okay. Who else? Who else? Or what other parties involved in a power of attorney, guys? Sir?
Yeah, attorney in fact.
That's what she just mentioned. Yeah, power of attorney. And then who else? Or yeah, what other parties involved? It's not wrong. Huh?
Would it be like doctors or whoever's
No.
signing over?
Sue?
Isn't it the grantor?
Yes, it is.
Oh,
So the person who needs an agent to act on his or her behalf to deal with legal, financial, and/or healthcare issues. So the grantor is the person, giving that power of attorney to somebody to act on their behalf. I put a little picture here. Usually they're older, right? But so the attorney in fact, so the person designated in the POA to act solely on behalf of the grantor. So, like you said, power of attorney. Attorney in fact is really what the party is called, but yeah. And then the grantor, like we said. Can anybody tell me the different types of POAs that we typically see here at the credit union?
There's verbal and non-verbal, if I'm not mistaken.
Yeah, those are more of in regards to if it's effective or not, but that's kind of yeah. But no, there's three different types. Yolanda?
so one would be like a healthcare director.
Well, that's a different type. That's a different type of document. That the POA can be part of that, so they can take care of the health. Sue?
A general power of attorney.
General. What else? There's two more.
The school's first POA.
School's first POA, and there's one more.
Is there one where you can act on behalf of like the trust?
Yeah, it's still a POA though. It just gives you POA over the trust. Alright, we'll go into it. So the school's first POA is to grant access to the attorney in fact for school's first accounts only. Are we all familiar with that we offer that kind of POA? And it does require two witnesses. We typically do that here at the branch. The person, the grantor will be here, the attorney in fact will be here. It's just a paper really that you print, they sign off on it, and then two witnesses, yourself and another team member, and then we affirm the account. That you can go through the SOP. But what questions do you guys have on this? Danny?
The school's first special POA does not apply to trust, though, right?
No, it doesn't. No, it does not apply to trust. So it only applies to the member's account, no trust on it, and they get to choose what shares they want the attorney in fact to be able to act on. I guess a little more context on that. So if they're all on all shares, if the POA is on all shares, then they're able to like open or close shares. They have that capacity only if they're on all the shares.
We don't need any documentation necessarily, right?
No, nothing.
They can just say like, oh, I want to add this person to our attorney because perhaps the RTPOA form and they can just sign
Yeah.
it and just get to it.
Super simple. So we hear it all the time, right? If you're on the teller line, or maybe a quick conversation at the front desk, and a member's like, "Well, what if something were to happen to me? Can I have my sister, my daughter, whoever to have access to the membership?" This is a perfect way to advise a member. We do have something that we're able to offer. Maybe it's something quick. Maybe they're gonna have surgery and they don't know. They don't know how long the recovery process will take, and they need to keep up with their bills. They want somebody to be able to do all that for them. So this is a perfect opportunity to bring this up. I know sometimes a lot of members don't even know. They think they have to go to an attorney and get it done. That's the other way to do it. But we also have our own just for the credit union. And we always want to set that expectation that it does not apply to any loans. It doesn't apply to any retirement accounts. just strictly to the shares on the membership. Any questions on that? The third one is the statutory POA. When you notarize documents, we're able to see a little bit more of these. Typically, the ones we see are the general, but statutory just means that it's pretty much, it goes hand in hand with the way the law of California wants it to be. That's the only difference. I don't know if I've seen any of the, say, statutory POA. More is just general, but that's one of the other forms. And then, like you said, general. And typically it's broad, and it kind of gives you an extensive amount of powers. I've seen members do this all the time by themselves, like on the internet. I don't know, people who notarize documents. It looks pretty similar, and it kind of has a whole list, and the member would just kind of initial the powers they want to give to the person. Obviously, they can do this with an attorney as well, but the ones that I've seen are general ones that members can bring in. It's usually kind of looks the same. They usually get it from online. And then it also provides limited authority with respect to specified permissive actions or purposes. Our POA is always in effect, so kind of going to what Kevin was bringing up earlier. So what did you say earlier?
Durable and non-durable.
Okay. And is there any other types that we deal with? And maybe there's more, but I know there's 3 types. So we'll get into it. So durable, it remains in effect after the grantor becomes incapacitated. So there's some power of attorneys that might not, but when it says durable, it means that even if the person would be incapacitated, it's still in effect. Non-durable is no longer valid when the grantor becomes incapacitated or disabled. These, I don't think I've seen many of these. Maybe I haven't even seen them here. But pretty much, if the person granting the power is incapacitated or disabled, it no longer works. And I think, I don't know, to me that would defeat the purpose of the power of attorney. But there is these types that we might come up across here at the credit union. And there's another type, springing. So that just becomes effective at a specified future time or on the occurrence of a specified future event or contingency. It could be incapacitation. Maybe the member is, not that old and they have a power of attorney, so they don't really need anybody to take care of their finances now. But maybe they've designated so, well, when I'm incapacitated or when I can no longer take care of my own finances, then, XYZ person will take care of all that for me. What questions do you guys have on those?
So I guess for the springing, so let's say I put a power of attorney on my membership for when I go into labor in case there's any things that go wrong. Would I use a springing then? Because I don't want anyone taking care of my stuff unless.
Yeah, I mean, I think that's one of the, it's pretty much up to the person and the way that the power of attorney is designated. Obviously, we'd bring that up to SAA and they'd be the ones to interpret it. I'm sure that they'll have to have some kind of doctor's letter, to say that they are, in labor or whatever the case may be. But I think those are kind of rare. I don't see too many of those. So, like I just mentioned, when it's our school's first POA, and how Melissa was saying, we can take care of that for the member. No questions asked, as long as we can tell that the person's acting on their behalf. They're not being pressured to do something like that. We're able to move forward with getting that form signed and FMing the account to be able to add all the information for the POA. But submitting those documents to SAA, you want to submit the POA documents, the checklist, and a copy of the attorney-in-fact driver's license if it applies to the situation. And if you guys are not familiar with there's a form on the SAA page that has these 3 questions for the POA checklist that you can either fax over to SAA along with the power of attorney documents, or the way I like to do it is I just place a note on the membership and say POA, set POA for review, and I answer these 3 questions. So what is the status of our member? Is the attorney in fact an existing member or joint owner in good standing? If they're not a member, then you take a copy of their driver's license and submit that as well. And what is the goal or purpose of using the POA? So we want to definitely be able to assess that situation. Sometimes the members are older, and so we want to make sure that we're protecting their account in case of any elder abuse or anything like that. So obviously, if you have questions, feel free to reach out to management or lead to walk you through the process. But we wanna definitely be able to answer these 3 questions before we even submit any documentation to saving the account administration. Cause if they receive a power of attorney documents and no paper with the checklist, then they're gonna be like, well, what is this? And they usually get kind of, they get a little grumpy. They'll call the branch and, hey, who submitted this, well, what's going on, what's the story? So we wanna be proactive and add those notes, or print the form out. I've seen people fill it out and then scan it along with the documentation. But I think that's pretty much it as far as power of attorneys. There's not much to it. Like I said, we don't interpret them. SAA, we send them up to them, and they'll be the ones to make the call and place notes. Keep in mind that this only applies to the membership, to the shares. If the member has retirement, like an IRA, or if they have 403Bs or anything like that, we would have to submit the documentation to each specific department. SAA doesn't forward it to the other departments. So if the POA states that the attorney in fact can act on like IRAs, retirement accounts, we would need to submit that to each specific department. What questions do you guys have on all that? Rose?
What do you do in the case where an attorney in fact comes in without the grantor want to be added to as power of attorney on the membership?
I think it's the same process. I mean, we definitely want to collect all of the information if they have the power of attorney documents, take them, but we do want to have full story as to, like I said, these are vital for the decision to see if we're able to accept it or not. What is the status of our member? Because if they say, I don't know, they're in the hospital or in a coma, so that's kind of a point of we can't even contact the member, right? But if they're in the hospital, maybe, I don't know, they had an accident, but they're still able to talk, nothing's wrong with the way that they're thinking, we can still contact them and see, what's going on. Like I said earlier, the point of it is to be able to protect the member's account. So if we have an attorney, in fact, I want to add myself to, I don't know, my parents' account, we definitely want to make sure we're asking these questions to discover really what they're looking to accomplish, what is the goal or purpose of using the POA, because maybe they just want to, use all the money, use their parents' money rather than look for their well-being. And so, like I said, we want to be proactive with those questions and be able to answer those when we have that conversation with SAA. And they might have other questions, because sometimes, I don't know, maybe the member's already joined or the person is already joined on a couple of the shares. So why do they now need access to the other shares? So those are questions you want to kind of be able to answer and know the full story of what they're looking to accomplish. Any questions, guys? Yolanda?
So for POAs, does that grant them access to online banking as well? Or is it only if the grantor gives them the password and username?
I think, I'm gonna have to double check on that one. But I think it depends. I think the power of attorney sometimes will say it. Are we talking about the school's first power of attorney?
Mhm.
I have to double check. Yeah, I can't remember off the top of my head.
What is the main differences between POA and a joint and beneficiary? Just main
Yeah.
differences.
So joints, have access to the account now. Kind of like we're talking with POAs, it kind of depends on what the POA documents state. But really, it just depends on what the member wants. Sometimes they rather just have their child or someone on the account already, just to have access, or the power of attorney. I mean, it just depends on what they're wanting to do. Because sometimes the power of attorney will only add them to certain shares. It just kind of depends on what they're looking to accomplish. And then beneficiaries, just if they were to pass away, then they would be the ones to receive any money on the account. Does that make sense?
Yeah, thank you.
As well as it being void when they pass away.
Yeah, so when the person or the grantor passes away, power of attorney is usually gone. It's out the door. Rose?
That's what I was gonna say.
Okay. Yeah, but yeah, that's usually I've never seen it otherwise. But you never know. I mean, like I said, we're not here to interpret those documents. SA will do that for us, so just submit them. If you have any questions, even if you feel comfortable with it, you still have to submit it first. They'll be the ones to okay it, and then we can move forward with the rest. Sue?
Sometimes you have to really read the account list, because sometimes we get notified by Social Security that the primary member has passed, but the power of attorney will still come in and try to do transactions, because they don't know that we've been notified. So we might accidentally do a transaction when they already passed and we're not supposed to. So you really have to look on the front screen when we get notified. SSA will put on their prime member primary member deceased on this date or date of death.
Okay.
Just adding to everyone and answering Child's question, joint, you could do whatever you want on it, in a sense, even if they were to pass away, they still have authority, but just like Sue was saying, if they were to pass, then power of attorney cease to exist. And the beneficiary, they're just on there if something happens, but they have no power, they can't do anything until they do pass away, and then they bring death certificate, and then we could process it from there.
Got it, thank you.
Does anybody have anything to add? No? You guys all look like you have questions. If you
Has
do.
anybody opened a power of attorney here? Do you guys have any issues with it? Have you guys had any complications? Maybe you could share.
I just always call FAA because they have all this paperwork, a folder they come in with, and right off the bat, they're telling me, I have this from their doctors, they're at this place, they can't come in, they're in hospice, or the other person is in coma, but they had documents, so because we can't interpret them, I just called SA, I forwarded the information, and SA actually put the power of attorney on the membership. And they just have me put notes.
You definitely wanna get a full story before you call SAA though, because you don't wanna be playing telephone with them. You know, where's the member? What's wrong with them? You wanna have your full story when you call SAA, so that way when you're talking to them, you have everything in front of you, and then go ahead and make a quicker decision for the power of attorney that's in front of you, so that they're not kept waiting either.
And then last thing, somebody asked about trust earlier. So if the member does have a trust on the membership, and this is just for you to know, like I said, you don't have to know how to interpret it. I've seen a lot of them, so I know kind of where to find all this, but if the person that's coming in has only POA for the member or for the grantor, they won't be able to transact on the trust. The POA documents would have to state that they have power of attorney over the trust, not the grantor, and that will give them access to the account, but that's just something for you to know. I like to set that expectation with members and say, you know, based on what you've read, or if you know, does this give you power over the trust? Sometimes they'll be like, I don't think so, and I just let them know. I'm gonna still submit it for review, but just keep in mind if the trust doesn't, or the POA doesn't clearly state that it gives you power over the trust, then we probably won't be able to accept it. I like to set that expectation for the member, just so or the non-member, in case, you know, that way they're not like keeping their hopes up, and we can maybe try to work on different solutions for them. Anything else?
To add quickly to that,
Yeah.
sometimes when they have a trust, I mean, we'll talk about trust later on, but they'll say, yeah, I'm the executor. So, like if they are looking to take over, oh, I'm the executor, that doesn't mean they're the power of attorney, so if they're the successor trustee, there's different steps on that. So that's something to keep in mind, like, oh yeah, I'm the power of attorney, but in reality, they're just the successor trustee.
Any other questions, guys? That was pretty much it on my end. Cool.
And scene.
Break?
Yeah, thank you.